We've been following Derek Chauvin and the George Floyd case since it happened. We covered it basically live. I mean, we covered it, I think, that same day. And it was something that has been percolating in the courts for some period of time. We're coming up on a trial deadline that's taking place in March. And so there's been a lot of activity in Derek's case. Derek Chauvin is the guy, the exact officer, you may remember this picture, who had his knee on George Floyd's neck for 9 minutes, resulting in George Floyd dying. Okay, and they're debating whether or not this is murder or not. I think you know my opinion on this. I think it was totally outside of his authority. I think he's not protected by qualified immunity. I think it was murder, and I think he is going to be probably convicted of this. But I wanted to run through his case because I want to show you all of the activity that's been taking place here. A lot of it. This is from the docket that you can find. It's part of public records over on the Minnesota court's website. And this is Derek Chauvin's case. A lot of stuff happening here. And remember, he's also sort of being prosecuted along with the 3 other officers who were there. I think it's Jay Kung, we got Tad Thao, and there's some other guy. I can't remember his name right now. But they're all sort of being prosecuted together. A lot of activity in Derek's case. So let's run through just a couple of what we're seeing here. We've got motions in limine. I'm going to explain what those are here shortly. February 8th, we also got a witness list. We got proposed jury instructions. So what are the jurors going to be listening to? It's just proposals, so you can debate those things out. A memorandum opposing the state's motion to reinstate third-degree murder charges came up. We got another memo, and the state submitted a bunch of documents here. So we've got the proposed jury instructions from the state. We got the state's prospective witness list, which is massive. I think there's probably, I didn't count them, but maybe 100 witnesses that are on that list. We have the state's motion in limine. We're going to dive into those specifically today. We're going to spend a lot of time, not a lot of time, but we're going to run through this section here. And we'll talk about what a motion in limine is. Then yesterday, we saw that there was these additional motions for admission of new lawyers. So Victoria Joseph must be an out-of-state lawyer because she's applying to join his defense team as pro hoc vice. So she's out of state, but she's asking for permission to hop on this case. Same type of thing here for, looks like Gray Kilgore. We've got another one here, Victoria Joseph, Harrison Gray Kilgore. So they're trying to get on the case. And then today we've got an order and a memo denying the state's motion to add back that third-degree murder charge. So most of this stuff is kind of procedural and routine. The big thing I wanted to talk about was this motion in limine, because these are interesting. And motions in limine are very frequently used in criminal law. And basically what they say is, well, I have a definition here. Let me show you what Wikipedia says. Don't take my word for it. In law, a motion in limine is a motion discussed outside the presence of the jury to request that certain evidence or testimony be excluded. A motion in limine can be used to get a ruling to allow for the inclusion of evidence as well. The motion is decided by a judge in both civil and criminal proceedings. We're talking about criminal law here. It's frequently used at pre-trial hearings or during a trial. It can be used at both federal and state levels. So what motions in limine do is you're sort of fleshing out the rules of the proceeding of the trial before it starts. So one of the easiest examples that I can give you is in a DUI trial. If you are going to be presenting your case, one of the things that officers like to do a lot is if they're going to be sort of performing the field sobriety test. So let's say your client's under investigation for a DUI. All right. The officer is going to say, well, I gave him the field sobriety test, and based on that, I thought that there was enough probable cause to give him a breathalyzer, arrest him, take him down to the station, and continue my investigation, draw a blood sample, and impound that into evidence, and blah, blah, blah. So they'll say, so sometimes defense attorneys will question them about the field sobriety tests, or we call them roadside agility maneuvers, to see how agile you are on the side of the road. They call them field sobriety tests. They call them standardized field sobriety tests because that sounds very official. Really, you're trying to, they want you to do cartwheels and stuff outside on the side of the road. It's kind of a joke. But the point here, I digress, is that when they are explaining their field sobriety test to the jury, one of the things that the police like to do is get up and show you how good they are at performing them. And the field sobriety tests are actually pretty hard to perform. I've actually done this in group presentations in different networking groups. When I have to present something, I'll stand up and I'll sort of read through the instructions. I'll pick a person who's a part of that group, and I'll say, hey, I'm going to give you some field sobriety tests. It's 9 a.m. You haven't had anything to drink, right? No, nothing. Okay, great. So you just read through the instructions that the police use in their legitimate investigations, and you ask them to perform it. Stand on one leg, walk and turn, any of those agility tests. People just fail them because they're not easy to do typically. And so what an officer will do in order to sort of rebut that and to show the jury just how easy these tests are is they'll get up and they'll perform them in the middle of the trial. So you have a police officer who stands up and says, yep, so here's what I did. I told them to stand here, and they just put their hands to the side and they just, move their feet like this. And the officers are typically, if they're inclined to do this, they're typically very good at it, right? It looks excellent. Like it looks like, oh, that's it. That test is super easy. You can just stand, put your heel to toe, take 9 steps. Don't lift up that last foot on that 9th step and just pivot around and heel to toe, walk your way back. And when the cops do it, it looks beautiful. You're like, wow, it's pretty easy. They got nice boots on. They're ready to go. They've practiced it 100 times. Now, a client or a random person you find at a restaurant or at a mall or a grocery store, they're going to fail it like 9 times out of 10. Because it's hard and you don't know how to follow the instructions. And so what a defense attorney, this is a very long story, what a defense attorney will do with a motion in limine is they'll tell the court that they don't want the officer to be able to stand up and perform the test in front of the jury, and they'll give them a laundry list of reasons why. Right? It's not probative. It's too prejudicial. The officer has obviously had a lot of training and experience here. Our client didn't. It's not relevant to the fact. The jury is going to be sort of biased by thinking, oh, well, it was so easy for him to do it, it must be easy for our client to do it. It's sort of a false equivalency argument there. And so you file this motion in limine to say, you can't do that, officer, and you ask the judge to hold that ruling. And typically the judge will say, yeah, you're right, it's not really relevant. He doesn't need to stand up and show it. And so you're arguing about that rule. Now, if you don't file it as a motion in limine, if you're not addressing it before you go into the courtroom, then the downside might be that you just don't know, right? If you're in the middle of your line of questioning, the officer might stand up and start performing it, and you go, whoa, objection, no, I don't want to do this. And now you're having this conversation in front of the jury, and the jury's going, that's weird. Why doesn't that defense attorney want him to stand up and perform those tests? That doesn't make any sense. And so the jury's mind gets all spun out, and they can lose sight of what the underlying issue is, what the point you're trying to make is. And so you want to just hash this stuff out before the trial even starts. Extremely long explanation of a motion in limine, but that's what they're doing here for Derek Chauvin. They're trying to say that the state government, the prosecutor, and this can be a little bit hard to follow because it's the government prosecuting a police officer. Typically, the government is representing the police officers, or they're on behalf of the police officers. They wouldn't like my categorization of that. They would say, no, we don't represent them. They're witnesses. Whatever, right? They're on the same team. Let's just put it that way. So they are usually on the same side. In this case, they're not. The government is prosecuting a former police officer. And what they're saying is when Derek comes into court, we don't want him to be able to do these things. And they're trying to hash these rules out before the jury gets impaneled. All right, so here's what they're saying is not appropriate. They say, number one, the first motion, defendant Chauvin may not impeach a witness with a statement from a third-party summary if the witness does not adopt that document as his or her prior statement. So the government, the prosecutor here, wants to prohibit Derek Chauvin from impeaching. So that would be sort of calling into question any witness with a statement from a third-party summary, such as a report that was prepared by the Bureau of Criminal Apprehension or the FBI, if the witness does not adopt that document as his or her prior statement. So in other words, they want to make sure that the witnesses are saying what the witnesses are saying. They're not taking some third-party statement from the FBI or some summary that was generated for them. Pretty standard, not that interesting, right? Judge will probably grant that one. The court should exclude any testimony by an expert witness concerning the opinion of any non-testifying expert he or she consulted. Okay, so you see how sort of in the weeds this stuff is, right? It's kind of hard to make sense of this. The state moves the court to prevent any expert witness. So if somebody comes in, let's say you have the person who performed the autopsy, the medical examiner, they come in. They want to prevent an expert witness from testifying regarding the opinion of any other expert he or she consulted who is not testifying at trial. So if the autopsy person calls another autopsy person and that other autopsy person is not testifying at trial, then they want the first autopsy person to not be able to reference the second autopsy person. Okay. In particular, the state moves to exclude any statement by a testifying expert witness that a non-testifying expert witness reviewed, supported, contributed to the testifying expert witness analysis or conclusions. Yeah, so this is like, these are so convoluted. Contributed or testifying expert's opinion, analysis, or conclusions, or that a non-testifying expert agreed with the testifying expert's opinion, analysis, or conclusions. So what they're trying to say here is you have one expert witness who's going to come in and they're going to refer to other testimony from other people who are not experts, and they don't want those other statements to be able to come in. In other words, you cannot have one expert witness who references and utilizes a bunch of non-expert testimony in their testimony. All right. So this is what lawyers do. Isn't this fun? We have Chauvin should be foreclosed from arguing incorrect legal standards to the jury or from presenting evidence specifically addressed to these incorrect standards. So this is a little bit more interesting, and you can see where the government's argument is coming into play here. The state moves to prohibit defendant Chauvin from arguing at trial that one, that the state must show that he intended to kill George Floyd. Okay. They don't want him to be able to say that. They want him specifically to not use that language, right? I didn't intend to do it. Okay, well, that's not the standard is what they're saying. Intention doesn't matter. Or that he intended to cause bodily harm. They're saying that's the wrong standard. Or number two, the state must show but for causation to establish that the causation element of the charged offense. We're going to talk about that a little bit more in the next slide. The state also requests the court prohibit Chauvin from presenting evidence or testimony that specifically addresses whether these incorrect legal standards have been satisfied. So we talked a little bit about but for causation in the context of the Trump impeachment proceedings, right? But for means something would not have happened but for that person's activity, right? This mug that I have on my glass would not have fallen over but for me knocking it off the table. If I didn't knock it off the table, it's going to be sitting there permanently. And so what was the cause of it falling off the table? It was me. It was my hand. It was my backhand. That's the cause. And what they're saying here is that they don't want Derek Chauvin to come in and say, I wasn't the cause of his death. My knee was not the cause. So what Chauvin's going to do is say, no, I didn't do it. It was something else. It was drugs. Probably is going to be the defense. And they're saying that's not the standard. Okay. You don't have to be the only cause. You don't have to be the but for cause. Let's go on to the next slide. The state, the government is saying that's because the state does not need to prove that. They don't have to prove the but-for causation. For the second-degree murder, the second-degree manslaughter charges, the state need not prove that the actions were the but-for cause of Floyd's death. Instead, the state must prove only that his actions were, quote, a substantial causal factor in Floyd's death. Minnesota Court of Appeals said the substantial causal factor test is more accurately worded, but in terms of but for cause, but rather the question is, was the defendant's conduct a substantial factor in bringing about the forbidden result? So was Derek Chauvin's knee on George Floyd's neck, was it a substantial causal factor in his death? Probably, right? And you're going to have to lean on some expert testimony in order to hash that out. A defendant's actions are a substantial causal factor so long as they, quote, contributed to the death. That's quoting a Minnesota Court of Appeals case from 1987. The state need not prove, quote, the specific mechanism of death or that the defendant's acts were the sole cause of death. Once again, quoting some of the same case law. Instead, the defendant's act only need to be a proximate cause of injury, meaning the defendant's acts caused injury directly or through a natural sequence of events. So they're just trying to get, this is why we spent so much time and I had so many issues with the Democrats' impeachment proceeding. They didn't spend much time talking about causation, just little touches here and there. This is critical. This is a huge part of the case. They're going to be fighting over this. This is why this is in their motion, because it's about causation. And this is probably going to be the entire crux of the defense. I didn't do it. He was on drugs. He was going to die anyways. I don't think it's going to be successful, but it's an argument, and it's actually a good argument. And our last one from them, it says the court should exclude or limit any argument, evidence, or testimony regarding the MPDs, so that would be the Minneapolis police decision-making process. Minneapolis, in terminating Chauvin's employment or MPD's civil liability. So obviously Chauvin got fired. He's in custody. The state moves to exclude any argument, evidence, or testimony regarding their decision-making process in terminating Chauvin. They also want the court to exclude any argument, evidence, or testimony suggesting that the Metro PD may face civil liability stemming from George Floyd's death. Why would they do that? Why would the government not want the defense to be able to talk about that? If they were to bring this up, if they were to say, hey, if you convict him, they're going to sue the hell out of the police department. Why would you not want that to happen? Well, maybe the police department is something that is looked upon favorably by the jurors. The jurors don't want the police department to be sued into oblivion. So maybe they say, well, we're not going to find him guilty then, because of the consequences that may impact the Minneapolis Police Department, which is probably the same department that governs where they live. And if they have a bankrupt police department, maybe they're less secure. So you don't want them to be able to talk about those things because it's distracting from the issue. The extent the court determines the evidence on these topics may be admissible for limited purpose for attempting to show bias. The state respectfully requests the court limit the evidence on such extraneous matters because it could lead to decision-making on an improper basis, confusion of the issues, and cross-examination that is only marginally relevant. Right? Extraneous matters. Confusion of the issues. Kind of hard to cross-examine about those issues. Right? This is the type of stuff that you fight over in a criminal proceeding. You didn't see any of this in the impeachment proceedings, right? Because it didn't follow any of these rules. This is the type of stuff you argue about regularly. Another interesting article came up today, which is what prompted me wanting to cover this story. Apparently, Bill Barr rejected a plea deal in the George Floyd killing. So when you're under investigation, when you've been charged with a crime, many of these things can result with a plea deal. You don't actually have to go to a trial. And it sounds like Derek Chauvin wanted a plea deal here, but Attorney General Bill Barr, who was formerly with the Trump administration, said, nope, no deal. Sorry. Here's what happened. He was the Attorney General. He rejected a plea deal days after Mr. Floyd died, worried about the protesters calling it lenient. The plea was for third-degree murder. As soldiers prepared to take to the streets, Derek Chauvin believed that the case against him was so devastating that he agreed to plead guilty to third-degree murder. As part of a deal, officials now say he was willing to go to prison for more than 10 years. Local officials, scrambling to end the community's swelling anger, scheduled a news conference to announce the deal, but at the last minute, according to new details laid out by 3 law enforcement officials, the deal fell apart after William Barr, the Attorney General at the time, rejected the arrangement. The deal was contingent on the federal government approval because Mr. Chauvin asked to serve time in federal prison where he wanted reassurance that he's not going to face federal civil rights charges. An official said that Bill Barr was worried about a plea deal so early in the process before a full investigation had concluded, probably a good move on that, would be perceived as too lenient by the growing number of protesters. Yeah. At the same time, Barr wanted to allow state officials who were about to take over the case from the county prosecutor who had tense relationships with Minneapolis' black community to make their own decisions about how to proceed. And then lastly, we've got the trial may be yet delayed. The prosecution has asked an appeals court to put off the proceedings, citing the risk that the trial, with so many demonstrators likely to fill the streets, becomes a super spreader event during the coronavirus pandemic. Yeah, I was not expecting this trial to take place next month. This appeal involves a question of exceptional and unique importance in one of the highest profile cases in our nation's history, according to Keith Ellison, the Attorney General. He is leading the prosecution. The state is also appealing a decision by Judge Peter Cahill to separate the trial of Mr. Chauvin, who is charged with second-degree murder and second-degree manslaughter. The initial charge of third-degree murder was dropped from the trial of 3 other former officers who were also involved in Floyd's death. 2 of them were rookies with just a few days on the job. The 3 ex-officers who were with Chauvin were Thomas Lane, who held Mr. Floyd's legs, J. Alexander Kung, who was positioned on Mr. Floyd's back, and Tao Thao, who held off angry bystanders. They're scheduled to face trial on aiding and abetting charges in August. And Chauvin's case is scheduled for Monday, March 8th at the Hennepin County Government Center. Do we think that is going to go? No, we do not. Is a trial going to happen on March 8th? I highly, highly doubt it. Typically, these cases can take a lot longer than that. I wouldn't be surprised if we see another year of pretrial proceedings before we actually get to a trial.